Well, the Union Cabinet, chaired by Prime Minister Narendra Modi, approved the proposal of the Ministry of Women and Child Development to amend the Juvenile Justice Care and Protection of Children Act of 2015 to introduce measures for strengthening child protection set up to ensure best interest of children. The amendments include authorizing the district magistrate, including the additional district magistrate, to issue adoption orders under Section 61 of the JJ Act in order to ensure speedy disposal of cases and enhance accountability. The district magistrates have been further empowered under the Act to ensure its smooth implementation as well as garner synergized efforts in favor of children in distress conditions. Defining eligibility parameters for appointment of CWC members and categorizing previously undefined offences as serious offence are some of the other aspects of the proposal. Several difficulties faced in implementation of various provisions of the Act have also been addressed. The amendments, once approved by Parliament, will increase the role of district magistrates and empower them to undertake inspections of childcare institutions. In this edition of The Big Picture, we will analyze the changes in the Juvenile Justice Act. Joining me on the program today are Deepak Kumar, former CEO, Central Adoption Resource Authority. Also with us on the program is Rosie Taba, member, National Commission for Protection of Child Rights. And we are also joined by Manoj Kumar Rai of the UP government. Thank you to all my guests for joining me on this edition of The Big Picture. All right, Deepak Kumar, let me start the program with you first. Let's first try and understand, analyze, some of the key changes really as far as, the JJ Act is concerned. How is it going to change things going forward?
Okay, I'd just like to first apprise that this Act was enacted in the year 2015 and actually was enforced from January of the year 2016. Thereafter, in 2016 itself, model JJ rules was notified, and specifically for adoption, the adoption regulations of 2017 was notified. Now, over a period of time, there were certain difficulties, or maybe there was certain shortcomings in the implementation of the programs, which affected this much needed amendments. Basically, if we look at the Act, there are two main verticals or pillars of this Act. One is for the children in need of care and protection, and the other one is for children in conflict with law. Now, the major four amendments, which you have rightly pointed out in the as an introduction to the program, the three of them pertains to the children in need of care and protection, and the fourth one to the children in conflict with law. Now, as far as children in need of care and protection is concerned, as per the Juvenile Justice Act, which is exactly in line with the UNCRC and other international best practices for the welfare of the children, we have two types of ways in which these children can be managed. First is the institutional care. That means initially the children who don't have anybody to look after, they are brought to some institution where they can be looked after and cared for. But this is always an interim solution. The permanent rehabilitation plan for each and every child has to be made, wherein they need to be integrated with some family. And the best way to do it is adoption, and in certain cases also foster care is there. So these are the aspects which needs to be covered under this Act, and which has actually been covered in the 2015 Act. But where we found difficulty was the implementation. Now, as you see, the implementation of this Act is at the district level. There are two major agencies who look into the implementation aspect. One is the Child Welfare Committee, and the second one is the District Child Care Protection Unit. Now, the problem with these two in the implementation was that the Child Welfare Committee members' selection, their eligibility, their qualifications, though they were defined in the Act, but still it required improvement so that we find a better set of people who can manage this at the district level. So that is the major amendment which has been brought in to strengthen the Child Welfare Committee. Also, we realized that the District Child Care Protection Unit, which is a small unit in the district, which is headed by a District Child Care Protection Officer. Now, they were either a very low-rung officer who did not have the wherewithal to actually discharge this onerous and important responsibility. And in many of the states, they did not even have a regular officer. It was actually a contractual outsourced staff who were looking after this DCPU. So there was a requirement to have a authority which is empowered, which is higher, and hence this responsibility now is being given to the DM, district magistrate oblique the district collector. And as it is, these two agencies are actually looked after by the DM oblique DC. So this will strengthen the implementation of the program at the district level, which will be of a great help in the rehabilitation of the children. Now, second major aspect which we find is the passage of the adoption order. Now, under the JJ Act, under Section 61, adoption order is supposed to be passed by the court, which is family court, oblique district court, oblique city civil court. Now, we realize that these courts, though they were supposed to take a decision in 2 months, which is prescribed in the Act, they were taking far too long. At any given point of time, over the last 4 years, we have observed that almost 800 to 1,000 cases are pending in various courts across the country. And this really affects the children and the adoptive families. Because the birth certificate can't be made, and the child cannot take admissions in school. Their insurance policies can't be taken by the adoptive family. And we used to get a lot of representation to get the adoption order at the earliest.
Right.
And this was initially highlighted to the Juvenile Justice Committee of the Supreme Court way back in 2016-17 when I was the CEO. And based on their advice, we started sensitizing the judiciary. So what we did is we held a number of classes of sensitization workshops in the various state judicial academy as well as national judicial academy over more than 1 year.
Right.
It did yield little bit of result, but due to frequent rotation of the judges and maybe due to other reasons, overall this pendency of the court adoption cases in the courts did not reduce, and it continues to be somewhere around that same figure.
Absolutely.
So we realized that
we'll come to this particular aspect and take the other aspects forward too, in the discussion. Let me bring in the other two panelists as well, who have been patiently listening in so far. So Rosie Taba, let me come across to you. So, as far as, the changes are concerned, does it make it easier now going forward for the authorities to ensure that the beautiful, law that we have is implemented in the right way?
Firstly, I would say that it's one of the best decisions taken by the government, perhaps, This was the thing we were telling, Deepakji, before this session started. I was just talking to Deepakji. In India, perhaps, each district is very different from another district, or region is very different from another region. And we cannot have a uniformity in terms of any law, perhaps. And JJ Act was one of such kind. Even when we used to go for our, visits and inspection, we used to talk to DCs, and we used to talk to DCPU, as Deepak sir was telling, DCPU, CWC. But what was that they were disconnected from each other. And right now, this very law has removed the ambiguity of it. It is clearly stated that DC or the district collector have to take the responsibility, and he's accountable and answer to the government or the authority, perhaps in NCPCR or SCPCR, for all the things that are concerned with the children in the district. This will perhaps give a very, very clear picture of whose role and responsibility. And, perhaps this will have a very good impact in a district also. When we talk about CWC, the JJ Act says perhaps there are parameters for appointing them. But a district may be very different, There might be, like in a place like Arunachal Pradesh or the Northeast is concerned, we see so much of qualification is not there. And perhaps many seats are vacant because of that reasons also. And now that DC will have the say that, no, I don't think my district needs this particular person or this particular, and this CWC have to work on a particular subject for the children. It would be very good. I think this is one of the best thing. And for a commission like us, who are the monitoring body of JJ Act, I think, it will make our work very easy. We'll directly go to talk to the DC, and we can directly take, our concern to him and reporting through him of the CWC and the other stakeholders of the children in the district.
Absolutely. All right. So, Manoj Kumar Rai, let me bring you in now. So, we've heard what were some of the difficulties, some of the, roadblocks really as far as implementation are concerned, So, what would you like to say about that? What were some of the biggest challenges? What continue to be some of the biggest challenges? How do we overcome them?
Thank you very much. Thanks for having me on the show. Well, first of all, I'll start by saying that legislature actually has reflected the will of the people. Because I, as Director WCD, Government of Uttar Pradesh, we have been implementing this act for ever since it came into being. And we have actually witnessed, as Deepak ji previously informed you, that there are certain problems in implementation of this act as it pertains to adoption particularly. We have seen that in cases of adoption, when the children are given to the prospective adoptive parents, and the litigation is filed in the court, in Uttar Pradesh, my experience is that cases are pending in the courts for as back as 2015. So it has taken 5 long years, and yet the cases have not been decided. And pre-adoption foster care has already been given. The parents and their anxieties, we can imagine that the kids are staying with them, but they do not have the order yet. In one of the cases in Varanasi, the child was born in 2007. The case was filed in 2015. So these have been the problems in implementation, this kind of bottlenecks, shortcomings, which have been witnessed by states all across country. And as Deepak ji told, that this has been flagged before Honorable Supreme Court JSC and State JSC, respectively State High Court JSCs, to ameliorate this issue. So the cabinet has rightly gone for this. We will very soon see the act being amended. And now what will happen is that, as you know, that courts, particularly civil courts, they are conducted through a set of rules. Civil procedure courts, criminal procedure courts. So the procedure court cannot be, they cannot be, they cannot cut corners. So all the procedures are to be followed. The lawyers strike, all kind of things keep happening. That is why this kind of delay has taken place. Once this onus goes to district magistrate, as we all know that a major part of this act, implementation of this act is already with the district magistrate. District magistrate has been already entrusted with the responsibility of supervision of CWCs. The act also empowers and demands upon the district magistrates to conduct a periodic survey, search and inspection of CWCs and send a report to state level selection committee. And then committee dwells upon that. So once this responsibility, once the district magistrate is authorized in this act, what will happen is the district magistrate, or he might appoint one of the additional district magistrates as the key person or a nodal officer for that. And we in state government, we can directly deal with the district magistrates as we keep doing pretty often. On every weekend or in every week, we do conduct online meetings. So we can always monitor the cases and we can always draw their attention that this kind of delay is taking place. Please do look into it. So first of all, the coordination will become smoother. Secondly, the procedure will become simplified. And thirdly, what I feel is that the prospective adoptive parents, they too will breathe a sigh of relief that the cases are being resolved very expeditiously. So this will actually help in all the stakeholders who are to be benefited, whose welfare is to be looked after by this act.
Absolutely. All right. So taking the discussion forward now, I go back to a point that Deepak Kumar was making. You were talking about the legal system, how, we've tried to bring about some changes. We need to improve the legal infrastructure as a whole as well, if we have to ensure that we bring down pendency of cases, and especially in matters relating to children and such kind of issues, isn't it?
Yes, I would further like to take this discussion forward as far as the major changes that adoption order will now be passed by the district magistrate or the district collector, or if he authorizes the ADMs. Now, what we realized is that judiciary is basically trained to adjudicate the litigations between two parties. So the decisions are always adversarial, the cases are adversarial in nature, and the judges are supposed to take a decision. Now, as far as adoption is concerned, these are not adversarial cases. And this is written in the JJ rules also. They are co-petitioners. The agency which gives the child and the adoptive family, they're co-petitioners. So there is no litigation actually going on. So the model JJ rule also says that the CRPCs will not be actually applicable in such cases in the court. That means there is no, the witness record of witness and other things are not supposed to be there. And there is already a statutory agency like the Child Welfare Committee which looks into the welfare of the child. They have declared the child legally free. There is a agency which does the home study of the parent to find their eligibility, suitability. So all the statutory checks defined in the Act and the regulations are already been done before the petitions are filed. So it's more of a just there's no decision as such, but it is just a verification of the facts before the orders are passed. So even the judiciary, which is already overburdened, was having this kind of a responsibility where actually no adjudication has to be done. So that is why it was imperative that it should be bestowed with the district magistrate or district collector, and he will be more confident in passing because all the instruments or the agencies who scrutinize the cases are under him. The Child Welfare Committee, the DCPUs, they are all working directly under them. We'll be more confident in passing the order, and the delay would be mitigated in this manner. So that was the main reason to have this change. Now, other points which they pointed out regarding inspection of agencies and all, they were earlier also supposed to be done by the Child Welfare Committee and the DCPUs. But yes, as I pointed out earlier, now the DM would be the fulcrum. He will be statutorily empowered or maybe made responsible for ensuring all these things. This would actually benefit the welfare of the children who are institutionalized as well. We will have a better check mechanism. There'll be more inspections in a formalized manner. So this will definitely help. Now, as far as our Act is concerned, one more comment I would like to make is, since I was handling inter-country adoptions also as a central authority of Government of India, our Act is one of the most robust and best Act as far as adoption and child protection is concerned, if we compare it with other countries as well. It is totally in sync with the Hague Convention for Inter-Country Adoption and the UNCRC. So even the US and all used to be very appreciative of the acts and the procedures which our government had notified after 2015. So we are quite doing well in that regard.
Absolutely. All right. Taking the discussion forward now, Rosie Taba, let's also talk about the role of the CWC and also, how they can help as far as the entire process is concerned.
Actually, the Act, like Deepak ji was saying, is very clear about everything. Only the implementation part was left. Perhaps it's because it was new at that time. But subsequently, in coming years, like now we are seeing that they are in a good position. And perhaps, CWC's role and function has been clearly highlighted in the Act. Now that this very, like sir was telling, fulcrum wala part, I would like to add that now that when we go to the, meetings in the districts or anything, we say CWC was doing that or DCPU is doing that. And, the functions were not clear to the DC about what he has to do. But right now, the very amendment has made it clear that the DC will be accountable for all the functions and that the CWC is doing. Perhaps CWC, like everybody is talking about adoption, I would like to highlight the other part also. Even with the adoption, when the child has to be declared fit before the adoption, that has to be done through CWC. And right now that has been made easy and under the guidance where DC will be a direct authority, I think it will be very smooth. And other things also when, CWC being the, very district they almost see the whole district CWC with the child welfare thing is concerned. I think with when they will work at the district, they will be more robust right now with the help of the DC. I also feel that somewhere down the line, when this act was created or when the act was made, I think the official structure or perhaps the training or perhaps all the things were all mixed up. But right now, the amendment has made it very clear that DC has to take the responsibility. And I'm again and again saying this because most of the time when we go to the field visits or something like that, DC often say that I didn't know about it or I wasn't knowing. This was this was perhaps the duty of the WCD department. This is concerned with child and woman, and it was not about me directly because I was handling other cases or other duty of a DC. So right now, I think we're in a good position. With related to the child welfare also and the act, which is one more thing I want to add, like sir was telling, everybody is talking about adoption. I would also add that the act has made it very clear that during the trafficking, the children in trafficking and in the drug abuse will also be considered as CNCP, child in need and care protection under. It's very good. And the other thing that has been made very clear is the differentiating of the offenses, petty, serious, and heinous, wherein the children will be protected in this regard also.
Absolutely. All right. So, Manoj Kumar Rai, since we are here, then let's also talk about the role of the state, the role of the officials at the district level, and is accountability also going to be fixed at that level so that we can see true results?
Yeah, of course. See, I mean, my experience, having worked in this department for some time, is that first of all, that there is not a lot of awareness about this act in the district authorities. District magistrate is an overworked official, as you know. He is in charge of so many departments, and he wears so many hats as well. Law and order and development work, all kinds of things, coordination. So first of all, we need to impart a very robust training program, not only for the district magistrate, but also for the district probation officers and CWCs. We in UP, we have devised a plan in coordination with the UNICEF to impart a certificate training program to all the CWC members. Because what we have witnessed is that despite of best efforts, CWC members are not intellectually and training-wise equipped to deal with the cases. And then due to lack of confidence on their part, lack of knowledge as well, the cases keep lingering. Because unless the CWC declares the child legally free, he is not fit for adoption. This again is one of the impediments which creates delay. The second part is that, as you mentioned about the role of the state government. So we have been working in a close coordination with High Court Juvenile Justice Committee. And we also been talking to the municipal magistrates and JJBs as well. As my previous speaker spoke about the fact that heinous, serious, and petty crimes, they are segregated under the Act. And all these children, particularly these children under petty and serious crimes, they should their bail should be given immediately. But it doesn't happen. In many cases, we have seen that children are languishing and they are incarcerated in the homes for so long. In the cases in which he or she should otherwise have been released on bail long back. So our sensitization on the part of the principal magistrates of judiciary is also out of the day. And we are conducting regular workshops in high courts, and high court judges and juvenile justice committees are imparting lectures and courses and trying to sensitize district judiciary that these cases should be taken expeditiously and the spirit of the law spirit of the act should be followed. Third part is that how to bring it higher in the priority list of the district magistrates, because as I earlier mentioned you, the district magistrates have many roles to play in the districts, and his attention is drawn to many expeditious matters which require immediate attention. So the role and challenge before the department will be that keep district magistrates reminding again and again and keep this issue right at the top of their agenda, because the children's right cannot wait. Children's right cannot be subservient to anyone's right. Child is the father of man, as we commonly it's told. So district authorities, they have to be trained, sensitized. The state governments have to be on their toes all the time. We have to keep ourselves abreast, and we also have to be in continuous coordination with judiciary, with the district authority and the central government. So this is one challenge which I foresee, that merely bringing about the act in the law is not enough. We'll have to keep ourselves abreast. We'll have to walk with the talk. So this is a challenge which I foresee for the state government, and we are sure that we'll be able to do it.
Absolutely. I think that's the attitude we need to have, and assurances from everyone stating that we can, trump and we can come up on top. All right. It's time to get quick closing comments now from all the panelists with the best way forward. I've got limited time, so I'm going to ask you to be brief, starting first with you, Deepak Kumar.
I would just like to close this discussion by saying that it's a very, very welcome and bold decision by the Union Cabinet. I hope this gets legislated very soon after the Cabinet has approved it, because we were observing these difficulties in implementation since almost 3 to 4 years. And it was a much needed change which was required. And I believe with this, both the institutionalized children as well as their rehabilitation and integration with the family would be faster, and we will have a better child protection systems as well as for those who are handling with the child in conflict with law. It will empower, because now there is a clarity in the definition of the types of crime: petty, heinous, and serious, petty, serious, and heinous, and also the quantum of punishment which has to be given in such crimes, there was some ambiguity. It needed to be reconciled because in one of the cases, the Supreme Court had observed it and had advised the government to do so. Based on the Supreme Court's advice, even this aspect has been incorporated in the amendments proposed and approved by the Cabinet.
Sure. Rosie Taba?
I think more of such talk should be happening. I think more of people like us should be coming. I'm so impressed by, I think, Manoj ji, who spoke as an, state representative here, saying that, making a law is very welcoming. This kind of law is very welcoming. But what we need right now is implementing it. We need to help the DCs at the district collector at the district level. We cannot, say accountable, you are accountable, but we as in force or we as in people working for children should understand and help them in all the matters concerned. And also I would like to say that, each act that is made for children, there is an essence written in the best interest of the child. When we say in the best interest of the child, each and everyone who are working for children should understand it and use it, while implementing their work and the law concerned. Thank you.
All right. And Manoj Rai, close the show for us with your concluding remarks.
Yeah, thank you. Well, first of all, I actually welcome this amendment in the Act. And I do hope that this will bring about a long needed, a very badly needed respite to the prospective adoptive parents. This will also, as my earlier speaker spoke, that deinstitutionalization should be the norm. So along with foster care, sponsorship, and adoption, with these three instruments, we shall be able to reunite so many children in their families, or we'll be able to root them in the family settings, because the family is the place where the child belongs, not the CCIs for that matter. CCI is the last resort, and it should remain a last resort. I can assure from the side of the state government, Uttar Pradesh government, that we shall implement this act in its letter and spirit, and we shall see to it that all the bottlenecks are resolved, all the issues are resolved, and the act is implemented as smoothly as it can be. And children's right is protected in its true spirit, in the true spirit of the law.
Absolutely.
Thank you very much.
All right. On that note, then, I'll call it a wrap on this edition of The Big Picture. Thank you to all my guests for joining me on the program and putting things into perspective for us. What's coming out of this discussion is that this was a